Hello everyone, it's your friendly, verified CIA shill here, and I'm back. And I've been gone for quite a while now, a couple of months, and I feel like I owe my handful of subscribers an explanation. When last I left you, I had mentioned that I was really busy at work, and I was in the middle of a move, and I was kind of delaying any video production, and that's true. Well, what happened after the fact was that something crazy happened at work, which resulted in a fantastic opportunity, pretty much landing right in my lap. I mean, it's the kind of offer that I'd be a fool to refuse, and so I didn't. Unfortunately, with the acceptance of this offer, it means that I have to move again. That's right. I just finished moving, and now I'm packing up to move again. But it's all good, though. It's all good things. In addition to that, I'm kind of sort of performing my job at two different locations, and there's been some travel back and forth. So, as you can imagine, I've been one busy CIA shill. However, I've decided I'm going to grit my teeth and get some videos produced because, to be honest with you, I really enjoyed creating the last couple that I did, those first 3 videos. So, moving on. If you are fascinated by the sovereign movements, as I am, and you have spent a lot of time listening to and researching their arguments and watching their videos and reading their crazy writings, and I'm sure many of you have, you'll probably notice a reoccurring premise used by most of these ideologies. And it doesn't matter what they call themselves. Freemen on the land, Moorish American, sovereign, national, it doesn't matter. Despite all the many differences that they have, one of the things they have in common is that they base all of their craziness on the same shaky foundation. They base it on some core assumptions, if you will, from which all of the later craziness comes from. And if you can show that this premise of theirs is faulty, well then, it's likely that everything that comes after is faulty too. And you probably already know what I'm talking about. I'm going to talk to you about House Joint Resolution 192. House Joint Resolution 192 and its accompanying law 73-10, the executive orders supporting it, and the events around it are the foundation for practically every sovereign free money or you don't have to pay your debts scheme. Most of these schemes, you may have noticed, are redemption or accepted for value schemes or variants of them with different names, and these schemes have been around for quite a while. The typical redemption or accepted for value argument, although there are certainly many variations, uses HJR 192 to assert that the United States went bankrupt and prevented us from using real money or gold to pay our debts. And some versions even go so far as to say that it prevents us from paying debts at all. We just pass the debt around instead. This is where some of the accepted for value versions stop, asserting that since debts cannot be paid but only discharged, you can have your debts discharged using the appropriate magical combination of paperwork with the right incantations printed across them in the correct colors and angles. Most sovereign schemes, though, do go further and generally go as follows. To back up the worthless, evil fiat currency that the government forced us to use and to get out of bankruptcy, many proponents of these theories assert that the government collateralized the U.S. citizenry, essentially using the lives of citizens to back up the currency and create wealth. They will often assert that birth certificates are utilized as the title, if you will, for this human collateral, not unlike stock certificates or bonds. Also, depending on which sovereign flavor you're going with, secret accounts were and are created for every citizen at birth, into which the government deposits your worth, which might be some arbitrary number or the estimated worth of your lifetime of work and production, etc. And the mechanisms for what generates this worth and how it works out, it varies greatly. This is where the creation of your straw man or corporate fiction all caps name is created, and this value or money is what you must redeem and use to pay or charge your debts to. So it would seem that we have three basic assumptions here. The first and most important one, Joint Resolution 192, was when the United States government declared bankruptcy. And because of that, we have assertion number two. The United States government then collateralized the citizenry, which leads us to assertion number three, that hidden accounts or secret accounts were created wherein the value of this collateralization is stored and that you can somehow access. So, is there a shred of validity to any of this? Did the United States go bankrupt in 1933, causing the government to do all of these other things that sovereigns claim? I mean, they certainly think so. Well, the best place to look to see if that actually happened is in the text of HJR 192 itself, or the law 73-10. It reads pretty much the same. And I'm not going to read it to you because, like everything written in 1933, it's painful to read and even more painful to listen to. It's widely available easily, so if you're interested, go ahead and look it up and give it a read. Now, there's no mention in there anywhere of bankruptcy or insolvency or default or any kind of term or verbiage that you would expect to see in that particular resolution if that resolution effectively declared the United States bankrupt. Now, we can stop right here and refute an assertion that many sovereigns, not all, but many sovereigns make when they say that the United States formally declared bankruptcy. Formally declared. Now, if you're a sovereign out there and you believe this, please show me in HJR 192 or any of the supporting executive orders of the time, please show me where the United States formally declared bankruptcy or insolvency. You won't find it in those particular articles that I just mentioned. And I haven't found it anywhere else. Now, I haven't been able to look through every single shred of documentation from that era, but I mean, if you're a sovereign out there and you think you have it, please, by all means, I would love to see it. Post it in the comments section. Of course, many sovereigns realize that the United States did not formally declare bankruptcy. They know that there's no evidence to support that, and they know that any evidence that's out there floating around on the interwebs is fabricated. But they will tell you that, okay, yeah, it wasn't formally declared, but it was implied. You got to read between the lines. And they have a little bit more of a point than those that would claim the United States formally declared bankruptcy. And they have a point because of the inaccurate way bankruptcy is used, or the term bankruptcy is used when talking about sovereign debt. Most of us know that sovereign nations don't go bankrupt in the true sense of the word. When a corporation or an individual goes bankrupt, they file for bankruptcy in a court. It's a legal action. However, there's no international court or other organization that a nation can file for bankruptcy in. That's why bankruptcy is a terrible term to apply to nations. A more accurate term is insolvency or default. Now, this isn't helped by the slew of lazy articles that are floating around, even in reputable sources, where they use terms such as bankruptcy when dealing with nations, but they do that because then people generally understand what they're talking about. And so at this point, you're probably saying, okay, CIA shield, that's all right, we're just playing word games. We're playing semantics now. And we are in a way, but words are important, as any sovereign will tell you, as they dust off a copy of Black's Law Dictionary to tell you what the legal definition of a term actually is. So we can all agree, I think, that the United States did not formally declare bankruptcy, as I mentioned earlier. But did we, in effect, go bankrupt? Well, even if we use the most uncharitable definition of bankruptcy in this context, which is that the United States government defaulted on a debt payment and didn't pay it on time, the answer still has to be no. The United States in 1933 did not default on any debt payments. They paid them all on time. They just paid them in a currency that wasn't gold. And before you go, Mr. Sovereign, aha, see? Well, that's why they defaulted. They paid in worthless currency. Well, that's just not true. The United States declared the currency, its legal tender, and mandated that taxes be paid to it in that tender. And that gives it value. When a nation with a working economy, even one in a recession, legally declares a tender and forces its population to pay its taxes in that tender, that gives it value, and to argue against that is ridiculous. The proof is in the pudding. The proof is in the reality of the matter. You could take that currency, even then, and you could buy real things with it. You could buy food, tools, equipment, cars, clothing. It had value. So we could again stop right there and say, okay, the United States didn't go bankrupt, hence it had no need to collateralize the citizenry to back up that fiat money, and therefore had no need to create straw men out of the population and accounts to store the worth and so on and so forth. But just for the sake of argument, let's step through those other two assertions anyway. Let's assume, just assume, for the sake of argument, that the United States did go bankrupt in 1933. And by bankrupt, of course, I mean insolvent, or it went into default. This is what you have to ask yourself, sovereigns, if you truly believe this entire line of reasoning. You have to ask yourself and answer, so what? So what? Nations going into default, nations becoming insolvent isn't a new thing. It happens all the time. I mean, it's happened quite recently, you know. Look into Mexico's history, Argentina, Iceland, the UK, Germany went bankrupt twice after both world wars. None of these countries, none of these nations lost their sovereignty. None of them disappeared. None of them ceased to function. They had a lot of hardships amongst their population, sure. But none of these countries were invalidated because they went insolvent, because they defaulted or quote-unquote bankrupt. Furthermore, if you do actual research into how these nations managed to claw their way out of insolvency, you'll see that they did it through quite normal means. They borrowed money. They devalued their currency. That's a big one right there. It's kind of hard to do, by the way, whenever you're on the gold standard. But that's another video. They imposed austerity measures, you know, spend less on welfare programs and that sort of thing. They didn't have to do anything so drastic as collateralize their citizenry. So why did we? Why did we supposedly do that? That's what sovereigns would have you believe, is that whenever we supposedly went bankrupt, instead of using all the normal methods that nations have used before and after 1933 to become solvent again, our government instead said, you know what? Yeah, we see all those methods that have been used before, and they work, but you know what? Screw all that. Let's institute a system that is so morally repugnant that we'll have to keep it hidden from our population for all time. No, that makes perfect sense. Screw all that other stuff that works. We're going to go this route for reasons. It doesn't make any sense. It's absolutely absurd. And besides the absurdity of it all, think about this. I mean, the U.S. government is doing something on a vast scale, and they've been doing it for a long time, supposedly, since 1933. They've been trading your birth certificates on the open market. They've been creating accounts and, you know, estimating your future value of your work so they can put money into those accounts and so on and so forth. People are running this. People are managing it. People are getting hired to do this and appointed to do this. Where's the evidence? They've been doing this since 1933, and there's not one shred of physical evidence that any of this is going on? Think about that. Because there isn't any. I mean, again, if you're sovereign and you think you have some solid proof that this is happening, some sort of documentation or log of activity, you know, if you have any kind of proof outside of you not understanding how online transfers work, then please put it in the comments section. I would love to see it. And so, to summarize, my evidence that the United States did not collateralize its citizenry is that there is no evidence that the United States collateralized its citizenry. We would have something concrete by now. It's been many years. We would have some sort of proof. Someone would have talked. You know, we would have found some sort of documentation. But none of this has been found. Anything that sovereigns say has been found is always easily debunkable, almost immediately. It's usually fabricated or some naive, childish misinterpretation of law or a definition out of Black's Law Dictionary or something like that. It's never anything that anyone with a computer can't debunk with 2 or 3 minutes. And so you may be asking yourself, well, why are you making this video, Mr. Shill? Well, the first reason is because I am a verified CIA shill, of course. I get paid to do this, obviously. But the main reason is because if there was no bankruptcy, no true bankruptcy in 1933, then there was no collateralization of the citizenry. There was no monetization of the birth certificates. A for V, accepted for value, doesn't work. There's no reason to file secured party creditor or UCC1 because the mechanism by which all these schemes work rely on the quote-unquote bankruptcy of the United States in 1933. And I think I've shown you that the United States didn't really go bankrupt, although some people would use that word, just because it defaulted on its promise to redeem gold for its currency. It didn't truly go bankrupt. It didn't truly become insolvent, although we may have very well been heading that way. We staved that off with some quick thinking and unconstitutional actions, which we all can second guess. We have the luxury to second guess. But my final bit of proof, my final presentation, if you will, about the invalidity of the bankruptcy of the United States in 1933 and how it does not mean you get free stuff. It doesn't give you any sort of remedy. It doesn't make the redemption theories work. It doesn't mean you have a straw man. There's no acceptor for value that works because of it, etc., so on and so forth. My final assertion is that according to the sovereigns themselves, this is a legal process. These things are telling you that you can do to discharge debt and get free things. It's a legal process. It's a remedy that was put in place because of HJR 192, and the government doesn't want you to know about it. It tries to scare you away from it. It tries to hide it from you, but it can't stop you from doing it if you persevere and you do the correct and legal paperwork, the correct forms, and send them to the correct people. Then the government has to give you your way. Now, the biggest problem with that, of course, is that the federal courts, the institutions that would allow you to do such a thing, ultimately, they don't agree with you. Not in the slightest. There are plenty of court cases where people have tried to use these schemes to get free things, to pay debts, to get money. They've taken it to court and they've lost every single case. I challenge any sovereign to find a single court case where they won on the merit of their argument for any of these HJR 192 derived remedies, except for value and so on and so forth. There are plenty, of course, where they lost, and there are several that I could show you. Obviously, I can't do that. This video would be hours, but I'm going to show you my favorite one, because this one right here is a nice summation, I believe, of how the federal courts view all such HJR 192 based arguments. So here we have a federal district court case, and it's Michael Sanford versus Robbins Federal Credit Union. Michael Sanford attempted to buy a car using one of these fraudulent methods, a combination of them, and the defendant, which is Robbins Federal Credit Union, filed a motion to dismiss, and on the lack of jurisdiction for federal court, and the court did dismiss it because of that. But it was so intrigued by the silly argument of Michael Sanford that it actually went past the dismissal and went on to explain basically that we dismissed it because this is not a federal court issue. Seeing as how Robbins Federal Credit Union is not a federal actor, but even if that weren't true, his argument still sucks, Mr. Sanford's, and we're going to tell you why. And it makes pretty good reading. Like I said, it's a nice summation of the failure of these kinds of arguments in court. So I'm going to skip through a lot of the front matter, and here we go. Here they address the House Joint Resolution 192 based arguments. And I'm going to read it in its entirety for these last couple pages because I feel it's important to do so. It's pretty enlightening, or it should be. So bear with me. I know the video has been long enough. But it goes, additionally, the plaintiff's reference to House Joint Resolution 192, 73rd Congress, 1933, enacted by Public Law Number 73-10, is also insufficient to state a claim upon which relief can be granted. House Joint Resolution 192, titled "To Assure Uniform Value to the Coins and Currencies of the United States," states that obligations requiring payment in gold or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, are against public policy, and that U.S. currency is legal tender for all debts. And they list some citations here. Enactment of this resolution by Public Law 73-10 suspended the gold standard in the United States. The plaintiff declares that presentment of the electronic funds transfer instruments discharged his debt upon receipt of the instrument. Does that sound familiar? And that his payment was in full accord with the resolution and public law. He adds that as a result of this law, there exists an obligation of the federal government, Treasury, to discharge debts in exchange for giving them credit to create and control the money system. Now, if you listen to April, June, that should sound pretty familiar to you. The plaintiff later explains that the discharge part of the system was established because of the bankruptcy of the United States of America in 1933. Frankly, it is not clear to this court how the plaintiff finds support for his claims in the United States suspension of the gold standard. His argument in this regard is vague and at times less than coherent, and I'm filling the judge on this point, having argued with many sovereigns. I know exactly what he was having to deal with. To some extent, it appears the plaintiff hopes to advance a watered-down version of claims other plaintiffs have unsuccessfully attempted via Public Law 73-10, such as the vapor money theory, sound familiar? Unlawful money theory, or redemption theory, C. McLaughlin versus City Mortgage. Now, that citation is an interesting one. I'm ordering the full filing for that because it is basically a compilation of all sorts of sovereign citizen theories, and as he says here, it discusses these theories in depth and collects cases that universally and emphatically reject them. And I continue. Such claims are equal parts revisionist legal history and conspiracy theory, and share a common thread in their use by plaintiffs seeking to avoid debt repayment. And that's what it's all about, people. How can these sovereigns avoid paying money for stuff that they bought or want to buy? How can they get out of their responsibilities? These theories appear to all somehow rely on various supposed consequences flowing from the 1933 suspension of the gold standard. For example, one tenet of redemption theory suggests that the United States has been bankrupt since suspending the gold standard in 1933, and that, as a result, the dollar is non-redeemable. Citizens thus became creditors for a bankrupt system, and the Federal Reserve note became a debt note with no intrinsic value, or so the story goes, and he cites McLaughlin again. Another variation suggests that when an individual executes a promissory note in favor of a bank, he has actually provided the bank money. April or June again. The bank then deposits this money into its own account, lists it as an asset on its ledger, and lends it back to the individual. Through bookkeeping procedures, the bank has supposedly created money, even though it does not actually have gold-backed funds available to lend, and the note is thus void from the outset. And he cites a case. It is not clear whether the plaintiff is making one of these specific arguments or whether he merely adopts some of their broader themes regarding the American monetary system. Parts of his response to the defendant's motion to dismiss have clearly been cut and pasted from the internet, so it is possible he is borrowing language he does not himself fully understand, or has included only a small piece of one of these theories. And again, I feel the judge. I know what he's talking about here. At best, this court can determine the plaintiff's central thesis regarding Public Law 73-10, remember that's HJR 192, is that by virtue of the 1933 bankruptcy of the country and suspension of the gold standard, American citizens provided credit to the federal government to create and control the money system, giving rise to the government's obligation to discharge their debts. To the court, this implies the plaintiff believes it is the government's ultimate responsibility to repay his car loans. They're just out to make a buck, people. But even if this were true, it does not state a valid claim for relief, as the government is not a party to the loan the defendant provided the plaintiff. As stated above, the defendant is not a government actor. Moreover, even if the plaintiff had more clearly described how this public law applies to his circumstances, he still would not state a claim upon which relief can be granted. And this part's important here. Courts have widely rejected arguments seeking relief pursuant to theories based on Public Law 73-10. And he cites McLaughlin again. This court now does the same. To whatever extent the plaintiff appeals to Public Law 73-10 as the basis for this action, he has failed to state a claim upon which relief can be granted. So the plaintiff's federal question claims are dismissed with prejudice, and so on and so forth. It is so ordered. And this happened on the 20th day of November, 2012. And there you have it, folks. A pretty cut and dry case there where the court is pretty much saying that this guy's arguments and others like it are ridiculous, frivolous, and that the courts widely agree with this. I mean, so if the federal government allowed access to these accounts because they had to offer a remedy because the United States went bankrupt and they had to collateralize the citizens or what have you, then why do the courts keep shooting these things down? I mean, if there's a legal process here to get at these accounts to utilize any of these HJR 192 derived schemes, you should find a court case somewhere that agrees with it, but you can't. You can't. And I think that's going to close this video up for now. I think we're all done here. Thanks, guys, for bearing with me for the last 20 minutes or so. I really appreciate it. And if you're a sovereign out there and you have any rock-solid proof, like I've said a couple times, please feel free to put it in the comments section. We'll have a discussion about it. I don't ban or block posters of comments unless it gets really ridiculous. And I promise I will try to get on a more regular production schedule now that I'm all settled in and settled down. So until next time, I'm your friendly, verified CIA shill, and I'm here to help.